CR1 is now in session.
Good morning. You may be seated. We are here on our case number 1CACV 140737, Stern versus Stern. All of you are been here before. You know that each side is allotted 20 minutes for your argument. The appellant may reserve any amount of time you'd like to use in rebuttal. The clock on the podium in front of you reflects the total amount you have, including what you may have decided to reserve. When you approach the podium, please recite, give us your name and the name of your client as well, please, because we record these proceedings. We've reviewed the briefs. We have studied the record at some length, and we've also discussed the case in our conference. So with that, Mr. Bain, proceed.
Good morning, Your Honors, and may it please the Court. Nice to see everyone. My name is Scott Boehm. I am appellate counsel for Plaintiff Brad Stern. With me at counsel table is Aaron Lloyd, one of Mr. Stern's trial lawyers. It's kind of a long record and a lot of potential areas. I've got a few points I'd like to make, but if the Court wants to steer me in a certain direction, I'm more than happy to go there. So. I think the easiest place to start, maybe the best place to start, is with partnership law itself. Three particular sections of the revised UPA are controlling, I think, of the underlying law aspects of the dispute between the parties. The first being Section 29-1001, subsection 12, which defines partnership agreements to include oral partnership agreements and oral amendments to partnership agreements. The second relevant section of the UPA is subsection 1003, which provides unequivocally that the oral agreement between the parties controls over the there's certain statutory provisions later in the act that would control in the absence of an agreement, because agreements can be implied as well. But when there is an agreement, that controls. And third, the third important aspect of this is this was cited quite a bit in the briefs, 29-10-12, which clarifies, and this was read to the jury a couple of times in the instructions, that an association of two or more persons to carry on as co-owners of a business for profit makes up the partnership. And everybody agreed here, and the jury was instructed that all the facts and circumstances that were discussed at the trial would be thrown into the hopper for the jury to decide initially whether a partnership existed. And we think, based on these UPA provisions, the key thing that is missing here that became so relevant to all these issues that we're talking about is there's no requirement in the law that a partnership be equal. Certainly the partnership agreement could provide that the partners are equal partners, and equally certain that was my client's position at trial. He agreed from the get-go of the case that it was a 50-50 partnership between him and his brother. The defense's side was not that, yes, there was a partnership, but it was something other than 50-50, either more or less one way or the other. But to the contrary, that my guy was merely an employee of his brother's corporation, and therefore that there was no basis for the six partnership claims. And the fundamental error, I think, is that the trial court inserted this principle of equality. And even ultimately, and I'm kind of getting ahead of myself here, one of the issues that we raised is the jury instructions. The preliminary instructions were fine. They accurately stated Partnership is what they agreed to, and as I mentioned, everything's going into the hopper. I didn't say hopper, and you'll decide. By the time we got to the final instructions, the jury was instructed, you have to determine if there was a partnership. You look at all the facts and circumstances to determine if there was a partnership. And then it skips down to, if you find that Brad proved an equal partnership, then you must find for him. And conversely, if you find there was an equal partnership.
Counsel, isn't it fair to say that the record is not lacking for both the court's inquiry and your client's assertion that it was, quote, 50-50 or nothing, end quote?
No, I mean, that certainly became the essence of what this whole waiver argument was. The 4 pages in the transcript of a preliminary, or excuse me, a final pretrial conference on March 7th. This whole kind of case comes down to pages 43 through 46 of that transcript. And it was a pretrial conference intended, that the whole purpose of the conference was to talk about some witnesses. We wanted to bring up certain maybe unsavory issues about a particular witness on their side, and they wanted to do kind of sort of the same thing about a witness on ours. So that was really what was at issue. And then all of a sudden, just this little 4-page snippet 3 weeks before trial about jury questions, the special verdict that we're going to ask the jury to define, because the predicate of this whole thing is that the parties stipulated 3 times. Initially, a motion was filed by the defense, and then the parties reached an agreement. A stipulation was presented to Judge Ray that the jury would determine a threshold issue of whether there was a partnership, and more importantly, what are the terms of the partnership? Knowing at that time, of course, that Brad was saying it was 50-50, but I'm more than happy to admit there is lots of evidence that it was something other than 50-50. Steve took more money, Steve may have done more things, but our position was, despite those things, it was a 50-50 deal. And that agreement, that stipulation, was confirmed verbatim in the record by Judge Ray when he set the trial. This is the 2 issues we're going to go to trial on. And then when the parties filed 2 joint pretrials, there was initial one filed, and the trial got continued, and they filed another one with some changes, but significantly for this purpose, I'm eventually getting into your answer.
No. My nose itched. I didn't mean that wasn't a secret signal.
No. Get to the point, babe. But the second joint pretrial, which had the effect of amending the pleadings and controlling the course of the litigation under our case law, specified that the jury would determine questions of fact and law. Was there a partnership? Did they agree to an oral partnership, which is kind of the same thing? And third, most importantly, what were the terms of that partnership? So by the time the judge had this March 7 hearing, he knows, and all the parties know, that the jury is going to figure out whether there's a partnership and what are its terms. And that's going to require some questions of the jury. The judge at this hearing, to talk about witnesses, just says what at page 43, looking at the forms of verdict, and then Judge Ray states the parties' positions at the top of page 4. I mean, the plaintiff's position is there was a partnership, that we were equal owners. The plaintiff's position is just that we were just partners and equal owners, right? And Mr. Royal, who's not here today, confirms that's correct. And then the judge repeats the question, the specific positions of the parties. That we say it's 50-50, they say it's nothing. And Mr. Royal says, it's not really disputed. It's either 50-50. Your point, Judge, stating the parties' positions, is it's either 50-50 or nothing. And that's absolutely correct. There's nothing in that statement or in that discussion that purports, suggests, broadly hints at the idea that the defense jacked up, that constitutes a waiver of every other.
So your point is that when Mr. Royal says it's either 50-50 or nothing, he is saying, my point is my client says we have a 50-50 share. Their argument is there's no share at all, and there's no partnership. Okay, the problem, though, is that comes in response to a question about the proposed form of verdict. Now, I don't know that I haven't looked this morning at the proposed form of verdict that was on the table on March 7th. But we do run into that same problem with the form of verdict.
Right. But here's the answer to that. At the time of March 7th, there were two sets of verdicts. Ours was just you find there was a partnership or not a partnership. Their proposed form at that time, which is attached as an exhibit to both joint pretrials, has a specific question asking the jury to define the terms of the partnership. And there was no discussion about whether that was good enough, but the implication of the judge's questioning here, and they go on to discuss, and I think this is another significant point about this little 4-page thing, is nothing was decided there. At the very end of that, which would be page 46, the judge said, well, you guys all think about this, and then when we have more time, we will discuss what specific questions. So if you think there are more specific special interrogatories, we can certainly talk about those as we have time. Because again, this was not really the time to talk about the verdict. This was the verdict form. This was to talk about witnesses. So, and then the trial moves on. And at the time of the initial voir dire, and at the time of the joint pretrial, or excuse me, the preliminary instructions, and at the time of the J-Mall at the end of the plaintiff's evidence, all of this gets brought up again, and the judge says, correctly, there's nothing in the law that requires 50-50. So you don't get the win just because Brad didn't prove 50-50, which gets back to the UPA. But that's where this whole idea of waiver comes up. Mr. Rossi stands up and says, the next morning at jury instructions is when the whole damn thing gets derailed, in my view.
On the 28th?
On the 27th.
Okay.
At the arguing of jury instructions. Got my little notepads here. Oh, here it is, right here. They're arguing jury instructions early morning. The transcript is actually called the early morning proceedings because it was before the main trial started. And that's when Mr. Ross, excuse me, I have another case against a guy named Rossi, so I apologize to Mr. Ross. That's where he stands up and says that Rob Royal said at this March 7 hearing that we would lose if the jury found anything other than 50-50. And that's continued to be their position to this day. But it's simply not true.
Define for us what is not true.
It's not true that at that March 7, those 4 pages that we talked about, the March 7 final pretrial conference, it's not true that Mr. Royal waived on Brad Stern's behalf all rights, title, and interest to anything in the partnership other than 50-50.
Well, hang on a second, because you stopped your discussion of the prior testimony with the court saying other than half and half ownership, what other terms? It said, what I've got says that Brad's attorney then said it's not really disputed. It's either 50-50. Your point is it's either 50-50 or nothing to the court. Your point to court. The court says, well, I think that's your position. And it says that's right. That's
right, and it is our position. It's been Brad's position from the get-go. But no one ever said, and it would be insane to say. Let's keep in mind this is a corporate or a partnership worth millions and millions and millions of dollars, and both of these brothers made millions and millions of dollars in the 12 years that they operated as a partnership. No one would ever say, our position is 50-50, but if the jury, which we've all stipulated will determine what it was, finds it was 51-49, then we don't get anything. Because that would be nonsensical to give up millions and millions of dollars just because it wasn't a 50-50 deal. Now, again, our position, it was 50-50. And I used an analogy to a tort case. I do a lot of tort cases. And if the plaintiff's position is that this is worth $1 million and the defendant's position is this is worth nothing, well, it's not a light switch. It's not $1 million or nothing. If the jury comes back with $990,000, the plaintiff doesn't get walk away with zip, which is exactly what happened here. You were ready to ask a question.
Where in the record does the plaintiff object to the proposed jury instruction or the proposed form of verdict?
The objection to the jury instruction is at, and I quote this in the brief, it's at page 15, rolling over to 16 of the early morning transcript of March 27, 2014. And again, this is the first time instructions are talked about. And this is where Brad gets back to the emphasizes a couple of things and the discussion starts how long as we're talking about. I'm kind of running out of time, but this is very important, so I want to get to it. The discussion at those pages starts out with Judge Ray saying, now looking at your jury instructions, they're pretty much the same, except defendants have thrown in this equal partnership bit. And again, this is the morning after the J-Mall was denied because you don't need equal partnership. And this is where Rob goes off on his objection that he talks about the UPA and what the parties agreed and that 50-50 is not required. But I would just note that equal partnership is not what the statute says. Their proposed instruction, it's a fact-driven statement that they've added to the instructions. It possible could be a comment on the evidence. He corrects himself and says possibly could be a comment on the evidence. And then Rob clarifies that we presented our case and we continue to urge, and our position still is, we lost this, but our position still it was a 50-50 deal. The jury unanimously disagreed that it was equal. But that was our position all the while. But Brad, as Rob wraps up there, it's erroneous to put in the jury instruction equal. And then to answer your second question, that became law of the case. I mean, by that time, the judge wasn't buying it. He was completely dissuaded, I guess, convinced, duped, however you want to describe it, into this idea that Brad was either going to get half or he was going to get not a darn thing.
But that presumes that the court overnight changed its whole view on partnership law.
It did.
But
he even says that and admits it. And I don't know if it's right here, but I talk about it in my brief. Within the same discussion, Judge Ray says, okay, again, you've got the timing exactly right. And he says at the end of this discussion, after Robbie says, you can't put equal in there because as you just ruled yesterday, it doesn't have to be equal. And then the judge says, well, I don't want to confuse the jury because up until this moment, I myself was confused. So Judge Ray is thinking at that time, boy, I was wrong before, when in fact, he was right before. And that's where it kind of went south. Now, to answer your other question about the form of verdict, by that time, ship had sailed. We were stuck.
Yeah, there's no point at that
and
point.
since you don't have to kind of be a jack in the box to keep up, I got 1:48 left. I'm going to save them if I can.
Thanks. Okay. Thank you.
May it please the court, Mike Ross with Gallagher and Kennedy on behalf of the appellees and the cross appellants in this case. I will probably reserve a moment or two with respect to rebuttal on the cross appeal issues, but those weren't addressed in Mr. Bem's comments. But I want to start not with my notes, not with the thoughts, but with the questions that the court has already asked of Mr. Bem. Number one, the March 7 pretrial management conference, of course, in time, was later than the joint pretrial statements from November of the prior year or from the spring of 2014. The final pretrial management conference was exactly what a final pretrial management conference is expected to do. It was a conversation about how this case was actually going to be tried, and it was a conversation about the case that the plaintiffs decided to try. Coming into that pretrial conference, there was a potential suggestion that the first question of this jury was to be, was there an oral partnership? The second question then, if so, what were its material terms? That's the conversation that's the issue that prompted the conversation at the March 7 pretrial conference. And with all due respect to the positions now taken, and these are not new, these are positions that were actually taken in the post-trial motions, Mr. Royal wasn't talking about 50-50 being their position and nothing being ours. And Judge Ray made that clear when he said, that's your position, right? If you read a little bit deeper into that transcript, you then see the discussion about the positions that they're taking. But that's not the only snippet upon which we are basing the view, and Judge Ray based the view, that the plaintiffs in this case decided to swing for the fences. They took a trial strategy that was an all or nothing approach. We're not privy to the work product and the reasons why they may have taken that strategy, but it's clear that they did. We knew that they did on March 7, and if it wasn't clear enough on March 7, we found out, of course, throughout the course of the trial that it was clear. On March 26th, we argued the judgment motion for judgment as a matter of law. On March 27th, we began talking about the instructions. And on March 28th, we talked again, this time presented with the final instructions that were going to be given by Judge Ray, March 28th in the morning before closing. And what resounds from each of those is commitment and recommitment to the position that they took a 50-50 or nothing approach. I can think of some reasons why they might have done that, including the fact that throughout the entire history of the case, Brad Stern had always said it was 50-50. And so was he willing to accept anything less and potentially contradict himself, contradict the 16 disclosure statements, the motion practice, the pleadings, etc.? No. They took that position. They chose that trial strategy. We asked again on the 26th of March, on the 27th of March, and again on the 28th of March, each time on the record, in the transcripts, the court can see Mr. Royal or Mr. Lloyd confirming that position. And so,
if that's so, though, what do you make of the discussion, the opposition to your motion for judgment as a matter of law, which was pure Hornbook partnership law? We don't need to prove any particular percentage. We just need to prove an agreement to be a partner, and we did that. And the court buys that. And wouldn't if you're right, and it was always Brad's argument that it was 50-50 or nothing, then wouldn't the context of that Jamal argument have been we prove 50-50?
the context, I believe, was that the jury, get to consider all of the facts and circumstances proved to decide whether they survived and proved their case. I think it's borne out when we talk with Judge Ray about what they get to use and prove to establish the partnership. There's conversations when we're talking about the instructions about whether they had to prove equal compensation, dollar for dollar, and whether they had to prove equal management responsibilities on a level playing field. And ultimately, partnership law says you don't, and we agree with that, and we agreed with that at the trial. We agreed that they could try to cobble together the framework of a partnership however they might choose to prove it. But at the end of the day, their decision, not ours, and certainly not Judge Ray's, was to take the swing at an equal 50-50 partnership, because that was consistent with the record. And so if you look, the way in preparing for this morning's argument, I started to think about, okay, put ourselves, because we get to, and you get to, not me, but put ourselves in Judge Ray's position presiding over this trial and managing this trial. There's zero incentive for him to take away from plaintiffs the opportunity to prove whatever case they wanted. Had the plaintiffs wanted to say, back to that original verdict form, question 1, is there a partnership? Question 2, what are its material terms, or what are its terms? They abandoned that position. They had that opportunity, and they said no. They said no on March 7th, and then again when we arrive at the final verdict form, the special verdict form, they participated in crafting that special verdict form. The court asked another question of Mr. Bem about the objections. They're not there. And I think if you look, and I'm certain the court, because this argument comes up very often about Rule 51 and the cases interpreting Rule 51, what constitutes an objection specific enough to meet not only the requirements, the black letter law of the procedural rule, but the cases interpreting that procedural rule. There are a couple of cases that I think it bears mentioning for the court this morning. The Duran case, we cited in our brief, talks about the notion that, at best, counsel's arguments at the meeting are a list of reasons why he believed the instruction to be confusing. Sounds familiar. And by the way, Duran holds that that's not sufficient. And the Grant versus APS case, in which the objecting party claims that the instruction was, quote, an improper statement of the law. This court says, no, that's not specific enough. That's not sufficient enough. And the rationale makes a ton of sense. The resources that were put into this trial were immense. And the opportunity to provide plaintiffs with the chance to present their case and to get all fair opportunity to present their case at the trial level, and most importantly, to give the trial judge the opportunity right then and there to correct the issue. Those objections do not meet the standard required by Rule 51. But at the end of the day, even if they did, the instruction itself was not a legal error. The instruction says that, in essence, you get to consider all of the facts and circumstances proved up or offered up by the plaintiff to try to prove an oral partnership. If it's up to you to decide whether all the facts, circumstances, action, and conduct and intent of the parties prove by a preponderance of the evidence that Brad and Steve were partners. That is accurate. That is the law. Then the instruction goes on to say, if you find that all of those facts and circumstances that you got to consider constitute an equal partnership, which is what was pled and claimed, then you find in favor of Brad. If you don't, you find in favor of our client, Steve Stern, Jamie Stern, and Senior Advisory Group. That's what happened here. They took that swing, and they proved their case. Now, why did Judge Ray deny the judgment, motion for judgment as a matter of law? I'm also not going to speculate. I will tell you that it's much cleaner for this court to have given a plaintiff the full opportunity to try his or her case and go through all of the steps. Now we have it submitted to the jury rather than a trial judge cutting the case off at the knees halfway through the case. It makes sense to me, and it makes sense to me that Judge Ray was tolerant in terms of giving plaintiff the opportunity to introduce all of the evidence that he believed supported a finding of an equal oral partnership. But that is the circumstance here. They took their opportunity. They confirmed that opportunity with the judge on multiple occasions. They tried that case on a 50-50 equal partnership, and the jury disagreed. The jury, given the full benefit of the evidence and the argument, found that there was not an equal partnership because there wasn't an equal partnership.
Let me ask you a question about an alternative argument that the appellants raised, which is that the court erred by refusing to take the juror note as a partial verdict.
Well, there's a difference in form, substance, and effect between a juror question and the jury verdict here. The question was not consistent with the charge to the jury, and it wasn't on the form. And an interesting point is no one, despite all of the efforts to convince the judge about where they thought he might have started going wrong as the jury questions came in. And I don't want to miss that point on timing, because all those conversations about instructions and verdict form were not, they didn't raise the problems or the issues or the concerns that we now see. The first time we start hearing that from Mr. Royal and Mr. Lloyd is when a jury question comes out. But at the time that jury question was provided to the court, no one stood up and said, this is a verdict. Let's read the verdict and poll the jurors under Rule 49. We win. Actually, what would have happened if that were the case is under Rule 49C, the court would have had the opportunity to send them back in to clarify the findings. No one in that courtroom believed or argued or ever hinted that this jury question was a jury verdict, and the verdict form was very specific as to what the charge was. As early as too early this morning, was looking for any case law to support that plausible theory that a jury question constituted a verdict. And I rescoured the briefs to make sure I wasn't missing some compelling point, legal point on that subject. I rescoured the reporters electronically to see if I wasn't missing some law that suggested that a question, which is followed by an actual verdict in the form, that question constitutes the actual jury verdict. And I couldn't find anything, but does that speak to my research skills? Possibly. Does it speak to the briefs? Possibly. There isn't any law, because you had another form that the jury was charged to find, and they were sent back to continue to deliberate, and they came out with an ultimate verdict that was consistent with the form. I think, quite frankly, that this case should not have gone to trial. I think that you cannot, under Arizona law, have a corporation and a partnership in the same envelope. I think that it's expressly prohibited by 29-1012B. I think the plain language of that statute means what it says. A business association formed under some other statute, in this case, the corporate code under Title 10, can't also be a partnership. Judge Ray disagreed. He disagreed in our briefing on the motion for summary judgment. He disagreed again on the ruling on our motion for judgment as a matter of law. But the statute has to mean something. And the plain language of that statute says that an association under 1 is not a partnership.
Couldn't you have a stock owned by a partnership? Stock in a company owned by a partnership?
Absolutely. Yes, Your Honor.
So couldn't that have been the theory?
It could have been. It wasn't. In fact, the questions to Mr. Too many Stearns. The questions to Brad, I apologize the informality there, but the questions to Brad were, do you claim any ownership in the stock of SAG, Senior Advisory Group? Answer, no. Record on that point is that the sole shareholder was and always was Steve Stern. And in fact, that SAG was actually the corporate successor to SJS Financial Consulting, Inc., which was a corporation formed by Steve years before he hired Brad. And could you, again, I agree, absolutely agree. A partnership could hold the shares of stock, a partnership or any other form, a co-op, an association, could hold the shares of stock collectively. But can you be both? And can you tell the world on this hand that you're a corporation, and then behind the curtain say, but we're really a general partnership, an oral partnership? And the best example I can give you of why that matters was actually a case involving Senior Advisory Group that was tried before Judge Ray 2 years or 4 years before this trial. Senior Advisory Group was a party to a lawsuit. They sued a former employee, Mr. Chris McDowell, and Mr. McDowell counterclaimed against Senior Advisory Group. Defending that case, Senior Advisory Group didn't say, well, we're not a corporation that gets the shield of liability. We're actually a general partnership, and so uncork the shield and the general partners are liable as a matter of partnership law, which they would have been. And that's not just Steve's testimony. It's Brad's testimony. Brad sat in the same witness chair in a trial 4 years before, and on cross-examination was asked by McDowell's counsel, are you an owner of SAG? And you know what he said? No. That's Steve's company. So it matters because it protects liability in the corporate form, where in the general partnership form you don't have that protection. There are a whole host of other reasons why it matters. I'm going to save my 1 minute and 23 seconds if it comes back around. Thank you.
Thank you.
To briefly respond to his last comment, Brad's never claimed an interest in SAG. That's the whole point of this. This lawsuit is not to get shares of SAG. That's why that Goofy Washington case that was cited, Chevalier, is different than this case. That was a partner selling an interest in a corporation that he didn't have. Now, if Brad was trying to sell or get some interest in SAG Inc., they might have a point. But that's not, and never has been, what this case is about. Now, the court does not have to speculate on why Judge Ray denied JMO. He says it. So I'm not asking the court or Mr. Ross to speculate. The judge said you don't have to prove 50-50. And the idea that the stipulation to decide this was just a suggestion, this is Mr. Ross' statement to the court on May 15th. Your Honor, it was by phone. Your Honor, Mike Ross, we called it a partnership issue with the stipulation and basically said whether there is an enforceable oral partnership And if so, what are the terms of that oral partnership? We're trying to spell that out in the STIP, which it was, and which it was spelled out again in the joint pretrial and the second joint pretrial. So the idea that it was just a suggestion that the jury maybe might decide the partnership issue, simply wrong. The idea that the court should dig deeper into the 4 pages of the March 7 hearing, where are you going to go? There's 4 pages. I've read it 20 times, probably 3 more today. And his suggestion, if you dig deeper, you're going to find out that Robbie wasn't actually just stating our position. He was giving up on everything. And keep in mind, the law for a waiver requires a knowing and intentional relinquishment of a right. Intentional and knowing relinquishment. That's not here. He specifically says twice, this is our position. So the idea that he's not stating our position, you can't get any deeper in that. Their whole waiver argument, the emperor simply has no clothes. I mean, you can say it 43 times, but there is no waiver, and I'm out of time. Thank you very much.
Thank you. Is there more to be said on the corporate issue?
You cannot coexist. Who holds the privilege? What do you do about the taxing authorities? What shield of liability applies? What governance in terms of the day-to-day operations apply? How do you wind it down? The Connecticut Supreme Court, before this statute was even part of the partnership law, stated it very succinctly in the Karanian case that we cite in our brief. Public policy doesn't allow a partnership to do business under the guise of a corporation as to the rest of the world while allowing the entity to be a partnership between themselves. This type of entity, that instrumentality, arm, alter ego, whatever wrapper they're trying to put around this theoretical relationship, doesn't work in real-world practical terms, pragmatic terms like the simple one. Who's liable in the event a third party sues that entity? I know what Brad Stern told the court, and I know how they argued it in the McDowell case. How would they argue it if they were to claim a partnership? We don't have to get there. They lost this trial on their strategy. They also lost this trial and should have lost this trial on the law that prohibits the coexistence of one inside the other. Thank you for your time this morning.
Thank you. Thanks. Thanks to both sets of lawyers. We are grateful for your briefing and your argument. We'll take the matter under advisement and issue a decision in due course. Now the court's adjourned.